was a violation of the Indian Civil Rights Act. What you can do next is refer, I believe, to our office or a private attorney or whoever to bring a habeas corpus action in federal court. You can, that's your remedy if there's a bad conviction in tribal court because of violations and the judge doesn't enforce the Indian Civil Rights Act. So you can help a client get a hearing in front of a federal judge to review what happened in the state court proceeding if in those circumstances. But one important factor is that before you do that, you have to exhaust the tribal remedies. So you would have to file an appeal to the Supreme Court, I guess.
Right.
And
Is that what happened in Charles Chip's case when he sat in jail for quite a long time?
I'm not sure, I don't know the facts
I
of
remember
that.
that
Is
case.
that the young man from over in Hot Springs?
No, he was from Guam.
Gary would
Well,
know about it.
charged in, was he charged in Fall River County, or where was he?
He was charged in tribal court and held for federal indictment, and they never came after him. So he did a year
He sat
in
in jail
tribal
for-
jail before the Supreme Court said if the tribes don't indict, if the tribe doesn't prosecute or the feds don't indict within 30 days, he has to be released. But he did like 13 months without a trial or a bond,
And then
without a bond.
they kept saying, the lower court kept saying, we're waiting for the feds to come and
Yeah.
get him. This is serious charges, which they were. You know, they were very serious, but we don't know what type of,
But the only evidence they had was
The
hearsay,
evidence, what type of
was
evidence they
reports
had
from
against him.
family members. There was no forensic interview, and you know, the US attorneys ain't gonna touch a case that
Well,
don't have no evidence, right?
under your code, he shouldn't have been held. I mean, there's not, you can't be held unless you're charged with something.
Yeah,
That's
that's,
happening a lot
Plain
down
and-
there.
plain-
Well, he
plain
was
and simple.
charged, but there was
Happening
no
now.
adjudication, you know what I mean? And no bond. The main issue was no bond.
well, that would probably be a potential violation of the Indian Civil Rights Act because under Section 7, the tribe can't require excessive bail. If no bond is excessive bail normally, unless there's some reason that you can't let them go. But normally, the Constitution requires an opportunity for bail, and now the Indian Civil Rights Act requires that same thing. So I would think you'd have a good argument that that was a violation of the Indian
Well, the
Civil Rights
Supreme
Act.
saw that, right? Gave him 30 days to prosecute him or cut him loose.
Also, at the same time, the court can set a bond hearing too, or bail,
Right.
hearing for bail.
But they didn't.
We did, we had
do
a
you-
bond hearing, we had a bond hearing in that case, and then we had VOCA. We had two tribal programs, VOCA and, the two programs came in and said he was a danger to his community, and Judge Lee upheld that. So they would not set a bond for him at no amount.
Now, that would depend, I think whether that's permissible or not would depend on your tribal code. I know you can't have excessive bail, but I think that's been construed to a case where if a person is really a danger to other people, let's say he captured Osama bin Laden and he's gonna blow everybody up, he's not gonna get bail. They're not gonna set, $1 million bail or something for him. So if a person really is dangerous, but you can't just be accused of being dangerous without having a
Right.
judge make
And
that
that's
determination based
exactly
on
where
some
the
sort
bond
of
hearing
evidence,
went,
some
you know,
sort of
there was
probable
like,
cause.
these charges, these are our kids, they're sacred, because it was sexual abuse charges, so.
In a case like that where the guy's getting held, I didn't see it in your criminal procedure section, but the United States Supreme Court has said that initial appearance has to be made within the first 48 hours. So if you have a client that's getting held for, a week at a time or something like that, you can go to the court and say, look, he's supposed to get his initial appearance, his bond, things like that.
So that's our
And
36-hour
then for
rule,
this
we
guy,
call
they
it.
even tried to,
Yeah,
they
what about that?
said that we're gonna, he's got a family friend and, in Rapid City, and he won't go back to Wombly, and he'll stay in Rapid City until the next court hearing, and they still didn't allow that.
Usually conditions like that will help get bond, but I don't know what happened in his case.
But they should be released.
I know there's no like federal detainment in the tribal code or anything like that, so the jail shouldn't even be holding them on a federal warrant.
Did he die?
they have a federal warrant, the federal, agents need to come pick them up right there. They shouldn't even go to that facility, but the tribe allows them to hold them. That's why they're being held on a federal hold, but a federal, that's non-existent. There's no federal hold. In that jail, there shouldn't be.
I think that the way that works, Ken, is I think what gives them authority is most of your tribal officers are cross-deputized and provided what's called a 638 contract. Okay? That's a contract, a BIA contract that the BIA has with the federal government, has with the tribe to make tribal officers also under this contract, and that's just the number that it's referred to by as this 638. That makes tribal officers, as long as they're working and they have one of those contracts in place as part of their employment, that makes them federal officers as well as tribal officers. What that does is give them authority to, if somebody has a federal arrest warrant, it gives them authority acting not on behalf of tribes, not in a tribal capacity, but on behalf of the federal government, gives them authority to arrest the person on a tribal hold. Separate from that, I think our United States Marshal's Office has a contract with the Pine Ridge Jail to act as a holding facility. In other words, if a tribal officer picks somebody up, you know, John Long goes, you all know John Long, right? John goes out, he gets a call from the marshals. Hey, we got a federal warrant for Susan Schrader. Go pick her up. John Long comes out and he picks Susan up. She's not charged with anything tribal, but he goes and picks you up. But we can't get you to Rapid till tomorrow. The marshals will be down tomorrow. So they have a contract with the jail, and they take you over and they stick you in the jail, and the marshals actually pay the jail sort of like for rent. Hold Susan, we'll be there, we'll pick her up. Now, if they don't have that federal warrant, they don't have a federal reason to hold her, and if she sat there for a week, I could get her out federally. There's no federal charge if that was bogus. Tribally, I don't think tribally. Well, tribally, a tribal judge couldn't let you out, and I don't think there's anything wrong with that, because you're right. There's no such thing as a tribal/federal hold, or there's no tribal authority to put somebody in a tribal jail on a federal matter, or hold them in a tribal jail on a federal matter. Where that comes from is they had to be somehow brought into federal custody, or if they started out in tribal custody, the tribe had to give them over to the federal authorities. But I do think that it's probably legal for the government, to the marshals or the Department of Justice or somebody, to pay your jail some rent space, and hey, we can't get down there for 2 days, could you hold this person? But anybody that's held in tribal jail for more than a day or two, I think they've got a right to demand, look, either somebody get me to tribal court and tell me what tribal law I'm sitting here on, and let me complain about that, or get me up to federal court so I can complain about, you know, why somebody can prove to me I'm being held on a legitimate tribal right. But I think that's how that happens. That's why people end up in tribal jail with that federal hold, is they've got officers that are working for both agencies, and they've got that.
But John's
that
BIA, John's
Right.
BIA, and then marshals and FBI are up here, so he's kind of like in between tribal and feds.
Right,
Because he's
right.
bureau.
Right, but he's, you know, and
he's
even if I use the example of the run-of-the-mill tribal traffic officer who's, you know, who's just a tribal officer, most of them, they make sure as soon as they become full-time officers, they sign that 638 contract. And, you know, that's why I defend people who, tribal cop stops somebody and arrests them for DWI, and the guy punches the cop out and runs away. That's why I end up with that case as assault on a federal officer, when that person's really just, you know, started out as a regular old tribal officer. It's because he signed that 638 contract, and he's technically working in both capacities.
And that was determined through case law too, right? Because
Well, there's
my
a law on
brother,
it.
my brother
It's
and
actually a
another
statute.
guy were, well, maybe there was another guy that, and I'm not gonna say names because he's an official now, but my brother and another guy, 2 other individuals and a woman, 2 other males and a woman, they beat assault on a federal officer. And having the federal court rule, district court rule that tribal police weren't federal officers, but by the time the appeal went through, Charles already did all his time, you
Yeah,
know what I mean?
well, and there's,
So-
that's part of the proof. I mean, if I get that case, that's one of the things I look at is, first of all, was the officer even a federal officer? Did he have that contract? I mean, I just did an assault on a federal officer jury trial 3 weeks ago. And that was one of the things we looked at. I made him show me the contract and prove to me that this officer, you know, was working in both capacities. If he wasn't, there's no federal violation. There's no, it might be a tribal court, you know, resisting arrest or some kind of tribal court offense, but we shouldn't even be here in federal court. Now, they were, in my case, the guy was a federal officer. He had that contract, and so he was working in both capacities, but, you know, but there's a law on that.
Yeah, U.S. Marshal's office, they don't generally have any federal facilities to hold somebody in pending a trial, so they usually contract with local, state, or county.
Right, like
Put them in the
my
county
clients in
jail.
Rapid City, they go to a state jail.
Yeah,
There's
they
no-
sit-
They're not a federal jail in Rapid City, but I have people held all the time. Well, they're paying Pennington County Jail.
Yeah, there's no state charge.
Room rent, just like I think they pay the Pine Ridge Jail.
Probably.
So years ago, did everybody get sent to Deadwood, like historically? Yeah, because I've heard cases.
Prior
from
to
30s,
1970,
they sent them to Deadwood
either 72
for, like,
or.
horse stealing.
Right, prior to 72 or 73, the federal court for the Western Division, actually, the federal courthouse was not in Rapid City, it was in Deadwood. And people went to Lawrence County, they went to jail up there.
They
Federal-
used the facility back then of the county, huh, years
Yep,
ago?
yep, they used county courthouse up there.
Because I have a great grandpa that was hung up.
I interrupted you, Mark.
That's okay. On the amendments, I just want to go over a couple more things. It said, there's section C covers the rights of defendants, and that's pretty important. It's towards the bottom of page 17. In a criminal proceeding in which an Indian tribe, in exercising the powers of self-government, imposes a total term of imprisonment of over 1 year on a defendant, the Indian tribe shall, 1, provide the defendant with the right to effective assistance of counsel at least equal to that guaranteed by the United States Constitution. 2, at the expense of tribal government, provide an indigent defendant the assistance of a defense attorney licensed to practice law by any jurisdiction in the United States that applies appropriate professional licensing standards and effectively ensures the competence and professional responsibility of its licensed attorney. Number 3, require that the judge presiding over the criminal proceeding has sufficient legal training to preside over criminal proceedings and is licensed to practice law by any jurisdiction in the United States. And 4, prior to charging the defendant, the tribe must make publicly available the criminal laws, including regulations and interpretive documents, rules of evidence and rules of criminal procedure, including the rules governing the recusal of judges in appropriate cases where they have to get off the case of the tribal government. And last, they have to maintain a record of the criminal proceeding, including an audio or other recording of the trial proceeding. None of that was required before 2010, so they really formalized a process that the tribe must follow before they decide to prosecute someone if they're
That's
gonna
kind
put
of
them in jail for a while.
right in with the timeframe of the Law and Order Act. Where are we at
Yep.
with that? Did that get funded other than Peterman coming
That's
down
right,
here?
part of the Law and Order Act is exactly what that is.
Yeah, it's part of, but where are we at with funding of the Law and Order Act?
That, I don't have knowledge on that.
Peterman got a salary, but that's about it as far as
Well, you know,
funding, right?
the interesting thing is if you don't fund it and the tribe can't afford to do these things, then as an advocate, you say, well, then dismiss the charges against my defendant, because if the
Right.
tribe's not gonna comply with what they're supposed to do, they can't charge them under the Indian Civil Rights Act.
Right, I mean, let me give you an easy example. Let's say, I don't know your current tribal judges. I mean, I know the names of some of them, but I don't personally know any of them. But let's say the tribe hired somebody tomorrow as a judge who wasn't licensed to practice anywhere in the United States, was not a lawyer. Okay? Now the law says, the Indian Civil Rights Act, which has been adopted by your tribe, and the Law and Order Act says that a judge has to be, under A3, has to have sufficient training to preside over the criminal case and has to be licensed to practice law. So if you had a case and the judge you knew was not licensed to practice law, I think the first thing you do is you file a motion to dismiss and say, this case can't
But what if
proceed.
they're licensed in our tribal court? You know what I mean?
That's a violation of your law, because your law adopted the Civil Rights Act, and now that says, which means your law.
Aren't we a
yours-
jurisdiction in the United States, Mr. Kobach? We're a jurisdiction in the United States, so Oglala Sioux tribes, so wouldn't our our licensing,
Well,
body apply?
I guess that's a good question, Susan, and I don't know. I think until your Supreme Court found that, or you could find a federal case that said that, I would argue
Well, I'm
that.
gonna support our licensing of our tribe, you know,
Well,
that's what little
yeah,
sovereignty
and
we
that's
have left,
fine,
you
and
know?
that's fine.
Uh-huh.
Maybe you find out that the judge is from somewhere else and they're not even licensed by your own court. But, you know,
That's- yeah.
that would certainly be, I mean, these
Just
are the
work
kind of
it,
things
right?
you gotta
Just
look
work
at.
it
You have
out.
these rights. You gotta make sure that that's going on in every one of your cases.
Obama stated that we have the right to go to tribe to represent each other.
Right?
So how does that fit in here?
Well, I don't know what kind of, I think you'd have to look at whatever each tribal court, I think, has the ability to set their own rules for who can be an advocate, who can be a representative, who can represent people in their court. Just so your court has an application process and you have to pay a fee, you have to enroll as an advocate. And so if a person didn't do that, if they just showed up in tribal court one day and said, well, I'm not licensed here, but I'm licensed over in Rosebud, and so you ought to listen to me. I think your court could say,
Nope, they
well,
won't
I'm
allow
sorry, sir, you or ma'am, you can't, we're not gonna listen to you. You're not allowed to appear as an advocate. We have a process to follow. You haven't followed it.
On
Mr.
November
Falk, is this-
2nd, I won a federal court case in Reno, Nevada, using our supreme natural and our treaties. And so I think that is very important in what we're discussing. That's why I understand where you're coming from. I know where you're coming from, but what I'm trying to establish here is that as Native Indians of our land, that we no longer like to be lied to, and that if you're gonna have a court system that's gonna work, the United States government is federal. U.S. military, Army, Navy, Air Force, and Marines are federal. 564 plus federal recognized tribes are federal, not state, not local, but the ones that I mentioned, United States government, the military, and the Native Indian people. We are federally recognized. We should abide by federal rules and have one rule, not all these statutes or codes or things
Those
like
are
that. We
federal
should, you know, because a code is not law.
It's our
It's a
tribal
code.
law, our own
It-
tribal law,
That we're
It's-
following, that we're trying to
that we
work
made
with
for
it.
ourselves to govern ourselves with.
Right, but that's a federally recognized.
Mr. Falk, one point of clarification. This 25 USCS is an amendment to Indian Civil Rights Act, right? Or is it a piece of the Law and Order Act?
Actually, go ahead, Mark.
The Law and Order Act amended the Indian Civil Rights Act.
Okay.
So part of the Law and Order Act has now been changed, the language of the
According
Indian Civil
to the
Rights
Law
Act.
and Order Act?
25 USC 1302, that's the Indian Civil Rights Act.
Okay.
Okay, that's where you could find in the United States Code, that's what USC stands for.
Uh-huh.
In the federal law, that's where you find the Indian Civil Rights Act.
Because Endorse just informed me that our tribe did not accept the Law and Order Act. Is that true? Or do they have a choice to accept it?
Well, I don't know if your tribe has a choice to accept that, but the Law and Order Act was a law that within it made changes to a number of different laws. One of those, part of the amendments that Mark's talking about, made changes to the Indian Civil Rights Act. And so now part of the things he's been talking about are part of the Indian Civil Rights Act. Your tribe had already adopted the Indian Civil Rights Act and said, we want to be bound by that. We want to have the rights of the United States Constitution and those
Our
things.
tribe did
We
adopt
want
that?
our tribal members to have those same rights under the Indian Civil Rights Act. So you'd already done that, your tribe had already done that a long time ago. And all that Tribal Law and Order Act did was add some more protections as part of the Civil Rights Act. So I think unless your tribal Supreme Court said, or your council said, you know what, we've got the Indian Civil Rights Act and we like it the way it was, we don't want to take these new changes, which I don't think they do, they're beneficial. they're
Do
helpful.
we have
They
that
do.
option as
I
a
don't think
tribe?
you have
though?
the
Because
option
on
It's
that.
federal law,
Yeah,
right?
I think you'd either have to disregard it all or take it as it is. And your tribe is taking it as it is. Now, I don't know enough about the Law and Order Act, all the other amendments and all the other laws that were changed. I think you can kind of choose to follow or not follow some of those. But
Well, it was
you
a
have
big
the Indian
beat, it
Civil
was a
Rights.
big blurt. Remember when
Right.
Obama first
Oh,
got
right,
in
right,
and
right. It's all
Jody Gillette and out of Obama's office, a tribal member from Standing Rock was going around and stuff, but then where's the money, right?
Yeah.
That's why I was teasing because
But
only
these,
Peterman got a piece
these
of the
laws
pie.
apply, these laws apply that we're talking about, because your tribe is adopted the Civil Rights Act.
Did you have a question?
Yeah, that's, Susan was kind of talking about that. I came to a Judiciary Law and Order Committee, and they stated that they've never accepted the Law and Order Act. And based on that, what you just read, that they have to be licensed. And our tribe, we have our own sovereignty. And we have in our code the right for traditional resolution. So in that, that's protecting our judges who are not licensed.
I believe your judges are probably licensed in your in the
Yeah.
tribal
Yeah.
jurisdiction, and the act just says in any jurisdiction in the United States.
Okay.
The Oglala, the Pine Ridge is a jurisdiction in the United States. And so if they're licensed by the Oglala Sioux tribe, that should satisfy the act, I would think. There was one other part of that I just want to mention real quickly. In our work in the federal system, sentencing is really important because so many people, like you talked about earlier, they plead guilty or they don't contest the charges, and so the best thing you can do for them as an advocate is try to get a good sentence for them. And we have a bunch of techniques we use in the federal system because they have guidelines that kind of apply and then other rules. The Indian Civil Rights Act provides for this. It says, in the case of a defendant sentenced in accordance with subsection B and C, those are the ones that are over a year, a tribal court may require the defendant, one, to serve the sentence either in a tribal correction center or in an appropriate federal facility or in a state and local government approved detention center or an alternative rehabilitation center. And now this is what's important, I think, or number two, to serve another alternative form of punishment as determined by the tribal court judge pursuant to tribal law. And that seems to open the door for advocates to say, you don't need to put this person in jail for 2 years. Let's have them do this community service, or let's find a better sentence that doesn't cost the tribe money and helps this person get rehabilitated, that sort of thing.
Helps the community.
Help the community.
That would
Because
be nice if we had some programs developed like that. We really need to work on.
I think we need that.
We really, really need that, because locking people up just makes them angry. You know, sets them up for maybe going on to federal or state prison. It's like a college for,
That's right.
or high school for prison, you know?
So if you can come up with creative ideas for sentencing, then I bet many times the prosecutors would probably agree and try to help you come up with things like that. I mean, there isn't any point in locking everybody up for as long as you can all the time. And so in the right cases, I would use that section of the Civil Rights Act to say, you don't have to put them in jail. Here's an alternative under the Indian Civil Rights Act. Even though the code might say that they should serve up to 3 years, you don't have to do that because of the Indian Civil Rights Act. That gives you that alternative.
All right, we'll talk, we're gonna talk this afternoon about sentencing and maybe some of that stuff, so we'll talk more about that, but that's your authority under the law to tell the judge, you don't have to lock people up, just because they got found guilty or
This is
they
really
pled
good.
guilty. That's not your only choice, is stick them in jail. The question's not how long they go to jail, the question is, should they?
Remember that, Vernon, I'm gonna be bringing you those arguments on Monday.
I wonder if we could take a break and let Scott, I don't know what time it is, but get Scott started.
Yeah,
Break.
let's,
Can we have a break? You know what, I'm gonna
Yep.
tell you guys that I went to our treasurer and the tribe is buying us all lunch.
Okay.
But I need to
Okay.
go set it up with.
let's take about a 5-minute break. We're a little behind schedule, so not more than about 5 minutes, but we'll take 5 minutes. Mr. McGregor's got some things on law issues.